I want to go before, and we have a common law trial.
I would demand it.
Okay?
Okay.
Can you demand that?
I would demand it. Absolutely. I demand it. All you got to do is say demand.
Yeah.
I demand it. It's not negotiable. I demand it. And I want it common law. I don't want your gold fringe flag in here. Okay, you bring a proper flag in here. Texas. Because I can show you, actually, I haven't found it yet, but I've been listening on talk radio, and there's some people that do say that even state courts are really federal courts, and the evidence is right there. I mean, they have a U.S. gold fringe flag in there. And so that'd be another thing I'd be telling them, is that I demand a jury of my peers. Okay, that's what you can demand. And I think I told you guys about that earlier, where people have actually tied them up in knots by doing that, because they have no right to subpoena state citizens in for a jury trial. You see what I'm saying? I mean, you could voluntarily come in, but they have no right to subpoena any state citizens in for a jury trial. They look for federal U.S. citizens, okay? And matter of fact, they go by the voters registration list, which everybody on there swears under penalty of perjury they're a U.S. citizen. And so that's the first thing you do, is tell them you want to talk to the jurors, and ask them, are you a U.S. citizen? And of course they're going to say yes. You know, 9 times out of 10 they will. If they don't, then they'll probably remove them off the jury. And if they do, then you can remove them off the jury. You see what I'm saying? I mean, that's exactly what the best way to get removed from one of their juries, if you don't want to be on the jury, is just tell them, well, I'm not a U.S. citizen. And they'll have you out of there so fast your head will spin, eh?
But I mean, you can say, I want to go to a Republic of Texas grand jury, and because you
I doubt that. I doubt they'll let you do that. But you can demand a jury of your peers. Okay? You're entitled to a jury of your peers.
in a de facto court.
Yeah, even in a de facto court. Absolutely. Yeah. Yeah, but it's all de facto. And so they got their hooks, okay? They're not going to let you go. They know that if you go before a jury of your peers, or at least a Republic of Texas, that you'll walk. You know what I mean? That's why in the colonial days they used to take people to England to put them on trial, because they knew they couldn't convict them here.
Yeah.
You see what I'm saying?
Yeah.
And so it's all admiralty. You know, I mean, they go and they put jurors in jail if they don't follow the instructions of the judge. You know, they do that all the time too. You know, again, you know, the best thing to do is stay out of there and lay the foundation so they don't want to talk to you no more. You know, that's what I essentially do. Anyways, there's no judge in a common law courtroom, okay? The first jury, common law jury, calls the witnesses, questions the witnesses, determines the law, the facts in the matter, and even pronounces sentences. The decision of a common law jury is not subject to appeal. The fact that you can make an appeal in the de facto courts is proof they're de facto. The decisions of a common law jury must be unanimous. The common law jury consists of 12 members. Many times some jurors of a common law, members of a common law jury didn't understand certain points of law, so they would ask someone who had been on a lot of juries, a jurist, to sit in on a trial to advise the jury on different points of law. But do you know what a judge is called? Called a jurist. It's true. So think about it. See, that's what happened, okay? The first jury recorded in history was in 1700 BC in Wales. And it was brought there by a group of people that came from the areas of the Caucasus Mountains. Think about that. Wow. And so what happened, and that's where the juries would call the witnesses, the questions of witnesses, determine the law and the facts in the matter, and that's where and even pronounce sentence. And so then what happened is you had people on the jury who didn't understand certain points of law, so they'd get someone to come in and sit in and advise the juries on different points of law. And then what happened is the government's got corporations, and so they had to have an attorney, and then, you know, everybody else decided they wanted to have an attorney too, and so then the judge gradually started taking over the courtroom and pushing the jury back to the point that they have jury instructions, and they even put juries in jail, or jurists in jail, if they don't do what they're told, you know, and so, but that's how it all started. And we have to understand that. Common law jury is king, okay? If a common law jury, if there's a judge in there telling the common law jury what to do, they can completely ignore his instructions and do whatever they want to do, and they can find him in contempt and have his butt put in jail if he tries to push the issue. And in fact, a common law jury, again, at common law, there's no jails, right? So, what is it? Death penalty. That's the only penalty. It's either death, and that's it. That's it. Death penalty. You know what I mean?
That's a good deterrent.
You don't mess with a common law jury. Well, they can fine and that kind of stuff, I suppose. Like the ones nowadays fine, they issue fines. And again, a common law jury is not subject to appeal. But there's really not much else they can do. They can issue a fine and make you pay something. And that's what these juries nowadays do. I don't know that. I don't think they've ever said anything about jail. Technically, at common law, there's no jails, and so jails are a benefit. Because the choice is death penalty, okay? And so then the jail, that's okay, I'll spend 5 years in jail instead of getting the death penalty. No problem, I'll be happy to be there.
Meanwhile, it costs us.
Huh?
Meanwhile, it costs everybody money.
Well, it's actually, what happens there, and I can show you in the Canadian presentation, I took it out of this one, but in Canada, well, it might be in this one. Let's see, let me think. Anyways, in Canada, and I'll bet you it's the same everywhere, okay? In the Solicitor General's budget, okay? The Solicitor General handles the jails, okay? In the Solicitor General's budget, all the money in the budget is for payrolls, okay? There's no money in there for jails. So how do you think the jails are getting paid for? Prisoners' bonds. That's what's paying for the jails. And the jails are all private. They're not owned by the government.
Prisoners' bonds.
That's right. And the jails are all private. In England, the Archbishop of Canterbury owns all the jails. The Church of England owns the jails.
Because they can tap into.
Well, it's a big money-making business. There's no doubt. But the real reason is at common law, the penalty's death. So we're going to let you go to jail, and we'll forego the death penalty, but we need you to pay for your jail cell. You see what I'm saying? And it all comes to the Vatican, actually, is who pays for it, is where it comes from. Yeah, that's exactly it. And that's all started with the debtors' prisons, too. Thank you.
So if you have a common law jury and then demand a jury of your peers, which are citizens of Texas, you're pretty much going to blow them away. There's no way they can comply.
Not really, not in the de facto system. Now that's not to say, their system's de facto, they don't have any authority, and any of their charges are all a bunch of garbage anyways. You know what I mean? But you have to understand, and this is one thing that we talked about with the FBI when they came to see me in the Texas Department of Public Safety. They actually said that the Texas Department of Public Safety officer told me, he told me I was sovereign 3 times, okay, and the 3rd time I was sitting there thinking, yeah, okay, you told me this twice before, I got that. But anyways, one of the things they said was they said that I think that I don't have to follow their codes, rules, and regulations. And I told them, you're right. But I said, I tell people, I do my private information shares, and I tell people they have to live a higher law. And the higher law is that even though I don't have to follow those codes, rules, and regulations, I do out of respect for those people in the area. And I said, if I go through a stop sign and I don't hurt anybody, then there's no injury at common law. Stop sign's a yield sign. I said, but if I go through a stop sign and I kill some guy, and he's married and got kids, then I got to pay to support his wife for the rest of her life, and I got to pay to support those kids until they're the age of majority. And there's no jails at common law. The choice is either do that or they take me out back and stone me. And so I choose to stop and to do those things that their codes, rules, and regulations soon, not because I have to, but because I choose to, because I respect those people in the area and I don't want to cause injury to anybody. And they kind of like that. You know, again, it's living a higher law. It's treating other people the way you want to be treated. You know, really, that's really what it comes down to. And respecting other people and their property. And another thing they asked me, they started talking about terrorists and stuff like that. And they said, so what are you going to do if somebody comes up to you about blowing up a bridge? And I told them, I said, don't be telling me about that because I'll turn your butt in. Well, that's true. That's not the way the Founding Fathers did things. You know, the worst thing they did is throw a bunch of tea in the sea, you know. I mean, that would be considered a terrorist event by today's standards. But so the point is, though, is that the Founding Fathers didn't go and hurt innocent people. They bent over backwards to get along with everybody. You know, that's not how they did things. And I think that's a good example of how we should be doing things. Anyways, a common law jury can do anything they want. Okay, it's we the people. We're the king. We can do anything we want. And they don't have anything to say about it. And now I still think that it would be well advised for us to get them, again, to administrate our public servants in the local prosecutor's office and the local chief judge and stuff, and get them to give us a place to hold our meetings. And they could probably even give us some guidelines on how to operate our jury, you know. But again, they're guidelines. They're stuff that we could take into mind and we can follow or we can ignore. You see what I'm saying? It's up to us whether we do or not, but we could ask them, you know, if they have any guidelines that we could use to operate our common law jury. I wouldn't think twice about asking them, you know. And at the same time, I'd probably tell them that, you know, we really don't have to follow these, but it's good information and to keep in mind. And you know, we're the king. We can do anything we want, you know. And I think that there'd be no argument. Whatever. I don't care if they want to argue anyways. It means nothing. You know, it's like the color of law. I tell them, that's color of law. That means nothing to me. That's right. That's what I tell them. Anyways. So, common law convictions, that I told you about this. This is about the Garland, okay? And Robin Boulanger procedure, again, this is something that Robin Boulanger in Edmonton did, is he likes to smoke marijuana, okay? And so he's in contacts with you know, other people that do that kind of stuff, but he's also very sharp on the law, I'll tell you. This guy's really sharp. Anyways, he's the guy, I don't know if you're on the group there that they talk about, Robin that's in jail. Yeah, that's him.
Oh.
Anyways, but he does things that I don't agree with, but he's really sharp, I'll tell you. He points stuff out about the law and stuff that's right on the money. Anyways, what they wanted to do is they wanted to open up, they wanted to grow marijuana plants in this head shop that was across the street from the courthouse in downtown Edmonton. Okay, and so what they did was they started putting out flyers. Okay, and it's all color of law. Okay, all of it's color of law, and so these flyers would basically lay out how their codes, rules, and regulations about growing marijuana plants were all color of law and had no authority and meant nothing. Okay, and they put these flyers out and they circulated them all around the courthouse. Okay, in that whole area of downtown Edmonton for about 6 months. And after they were done with that, after about 6 months, they figured, okay, well, we'll go ahead and start growing our marijuana plants. And they started growing them, and they were in this window that was across the street from the courthouse that they could see, the judges across the street could see, and they were getting real big and bushy. And one day, the cops show up, right? And the cops say, well, you know, we're not going to do anything about your marijuana plants, but we'd really appreciate it if you'd move them to another window because the judges across the street don't like looking at them. And the guy that was running the head shop thought about it for a minute. He says, no, he says, the plants like the light, so we're going to leave them there. And then the cop said, that's okay. I had to ask. See ya. And that was the end of it. Okay? Again, if we use administrative procedure and if we show them that they don't have any authority, then that puts them in the position of honoring their oath. And now they have no choice. They have to follow the law. You take away their discretion, okay? And that's another thing that I put in my court case that I just filed my lawsuit, I told the judge that he has no discretion in this matter, that I demand a common law jury, I